Good evening, and now my haere mai. Panel seems to be the loudest group here. We'll settle them down. Welcome to what I believe is the second to last UC Connect lecture for this year. Most of you probably don't know me. I'm Elisabeth McDonald, currently at the Faculty of Law at Victoria University. But later this year, very excited to be joining the University of Canterbury, and the most exciting bit probably is I get to be colleagues of these four fabulous feminists, among others, so really looking forward to that. So I'm going to start talking a little bit about feminist judgments projects globally and internationally, and how we got to the point of undertaking Feminist Judgment Project Aotearoa Te Rino, the two-stranded rope, here in this jurisdiction. I'm also going to, these four contributors to that project, all writers, are then going to speak for approximately 10 minutes each on some various themes coming out of that project and illustrating their own contributions while they do so. After my introduction, we'll hear first from Associate Professor Annick Masselot, and she's going to be talking a bit about what makes a judgment feminist. She'll be followed by Dr. Rhonda Powell, who gave the Law Foundation, and I should just give them a plug here, we were very, very privileged to receive some funding from the Law Foundation, which enabled us to not only move around the country and do this as a collaborative piece of research, but also to bring over from England Professor Rosemary Hunter, who has been involved in pretty much all of the Feminist Judgments projects internationally. So what I was going to say about Rhonda is I think that we were able to claim for the first time as a research project output in our report to the Law Foundation, the wonderful George, who's also here tonight. And Rhonda's going to be speaking about the challenges of being an academic in particular and writing a judgment, how a judgment is different from writing an academic piece. And Natalie, following a slightly similar theme but in a different tangent, I hope, will be talking about how to find your judicial voice. How does an academic or practitioner kind of don those robes to be able to actually engage as judges need to. And finally, the Dean of the law school here, Professor Ursula, will talk a bit about what I mentioned earlier, which is the collaborative nature of the project and what that means in terms of research. It's both its challenges and the excitement, I guess, of working in this way. And I should say we have 25 judgments in this project. 25 commentators, in fact slightly more than that in terms of judgment writers and commentators, so pretty much 60 contributors to this project from around the country, which is a pretty amazing and exciting thing. When I first started being involved, and Rosemary actually suggested to me, actually in Canada at a Law and Society conference, you know, if you want to do a Feminist Judgments project in New Zealand, I'll come and help you. And I thought, I don't know how many other feminist lawyers there are in New Zealand, and I think the most exciting thing has been about this project is how many have come out of the woodwork willing to put their names to a project that has that F word in the title, including, I should say, a number of men. And one of the interesting things about this project is we actually have a retired family court judge rewriting his own judgment. Which I think, we might talk more about that in the questions, has been a challenge in a number of different ways than for us attempting a judgment on the first time. So I should just say a little bit more before I hand over and not use too much of this valuable time, that the Feminist Judgments Project movement, if I can call it that, really started in Canada. And a number of feminist lawyers, academics in particular, had been quite successful in the Canadian context, being what they would call interveners and we would call amicus probably, of getting their arguments heard by the court and getting them taken on board. But they sort of started to feel like they were hitting a bit of a brick wall. They weren't getting the feedback, they weren't getting the buy-up really from the members of the judiciary. So they decided that they would just show them how to do it. And what they did was that they created a fictional court called the Women's Court of Canada and pretended that they were a court of appeal above the Supreme Court of Canada and heard appeals from the Supreme Court. following on from that, and this is really the approach that we've taken here, the UK Feminist Judgements project did things a little bit differently. They took actual judgments at various levels and rewrote them. And when I say rewriting, the important thing to remember is this is not us sitting in 2016 and thinking about what judges did in the 1970s and going, well, we can do much better now. The constraints of this project is that the judges have to rewrite the judgment limited by the precedent, by the law, by the social science research, by the arguments of counsel that existed at the time. It's quite a powerful, I think, illustration of what was always possible. And I think for sometimes it's been a challenge, and I think the panel might talk a little bit about that more. So I don't think I'll take up too much more time, because I think some of those themes and some of the things I said will be picked up by the panel members. But I'll hand over next to Annick, who's going to talk about what a feminist judgment might look like. What does it take to be a feminist judge?
Thank you. Kia ora, everyone. Yes, so I'm going to have a little bit of a wander around what a feminist judge might be looking like. There are some assumptions that possibly once women occupy position of power, once they are qualified enough and once they are equipped enough to become powerful or to be in position of power, that they will show us that actually it was completely illegitimate that they weren't part of this power, but also that they will share their experience as women, and they will also bring in some gender dimension to decision-making process. These assumptions are a little bit naive and possibly essentialist, and truly this hasn't been the case. We can all think about women in power who are absolutely not feminist. I don't even need to raise names. So it's more likely actually that the institution changes women rather than women changing the institution. It's also likely that those that are appointed in high power are more likely to resemble the establishment. It's more likely that they will not rock the boat. They will not try to change things. In fact, women have not been invited to and welcome in position of power, and welcome to certainly rearrange the furniture once they've been there. So they might be more likely to conform to the establishment and to what the situation that exists. So it's very unlikely that women in power will change things as such. This is true in the judiciary in New Zealand. We have about 30% of women in the judiciary in New Zealand at the moment, but we have women in power. So we have here Sean Elias, who's Chief Justice in the Supreme Court, the former Chief Justice of the Court of Appeal, who has now moved, Ellen France, who has now moved to the Supreme Court. So we have three women and 3 men in the Supreme Court in New Zealand. We have parity, so this is quite interesting. And we have the Chief Justice of the District Court, Jan-Marie, is it Jan-Marie? Oh, Jan-Marie Doug, in the District Court Chief Justice, female Chief Justice. So we have women in power in the court in New Zealand. And in New Zealand, in the Court of Appeal last year, we had for the first time a bench made of all women sitting for the first time. So this is interesting, and yet we don't see those feminist judgments coming through necessarily. So it might be more important to look at the relationship between feminism and power rather than women and power, because women don't necessarily deliver the feminist judgment as such. Feminists themselves have a political agenda. They are involved and committed into the interest of other women, and so therefore feminist and power might be more interesting. So the next question is, who can be a feminist judge? Does it need to be a woman? Can a man be a feminist judge? And there certainly are questions about that. We are still debating this question ourselves. We have in our judgment, in our project, we have some men writing feminist judgment. Can they be judged? Can they be feminist? Or do you need to have this gendered experience of life in order to be a feminist? There are arguments. But certainly we think that you need to self-identify as a feminist in order to be a feminist judge as such. Feminism is a conscious and considered and consistent commitment, I would argue. It is nonetheless possible for people to deliver feminist judgment, even though they are not feminists themselves. So we might have examples of feminist judgments made by people who aren't feminists, and we use those examples as good examples of feminist judgment, but we're not expecting those people to deliver constant feminist judgment. Now, the next question is, what is it that we expect from a feminist judge to do? Feminism, of course, has some substantive goals. Some of them include the achievement of equality, justice for women in the legal system, but also outside in society in general. And so we would expect the feminist judges to take those goals into account in order to produce those judgments. So some of the things that we might be looking for is that the feminist judge, is asking the woman's question. What is the gender implication of norms that might be looking neutral? Some norms look neutral, but in fact they might have gender implication. And it is arguable that in asking those gender questions, in asking those women questions, ultimately this will open other bias, maybe linked to race or sexuality or any other religion, any other. We'd expect that women take into that the women's interest is taken into account. The men's interest is often seen as the benchmark or the neutral benchmark. But in fact, it's only one aspect of life, and it is not the aspect of life. So it would be interesting to include the women's interest and their reality. The other aspect that we would expect is to have women's perspective, to listen to women's perspective, and also to have their story told or listened to or included. So we would expect those things. We would expect that this would challenge the myth, the stereotypes, those gendered assumptions about women, and we would expect in the long run, or ultimately, that this would not only take place in the judgment itself, but also in the reality. We would expect that the gender bias would be challenged. We would expect that the legal decision would be contextualized and not completely abstracted. So we would expect that there are some reality that are included into the decision, people's real life, and this would give some texture to the decision. We would also expect to find some address of injustice and inequality. So there would be behind the decision some idea of promoting better life for women and substantive equality, which would include maybe looking at the women's different position in society, but also to take into account historical or systemic disadvantage for women. Now, with all that, we would not expect that this is completely naive and that all the decision will be, that all feminist judges will be able to always take all of women's representation into account, that not all decision could take the women's stand. It's not always possible. Some decision will include making choices and setting priorities. So if you're thinking about issues such as wearing the headscarf, for example, what is the women's stance in there? Or if you're thinking about things like the protection of vulnerable women against their possible decision of self-harm. Do we protect them? Do we give them the rights to autonomy, even though they might harm themselves? Or if you're thinking about issues like raising the wages for childcare minder, knowing full well that if we do that, that means that other women might not be able to access childcare anymore. So if you're thinking about all these kind of decision, you see that there are issues of priority. In all that, we want to make sure, I mean, the feminist judges would want to make sure that the priority are set quite clearly, that the trade-offs are explained, transparency and accountability should be at the center of those decisions. And so that's with this that I would like to conclude and pass on to, who's next? Rhonda is next. Do you want me to take the baby, Rhonda?
That was a badly timed waking up. I had hoped he might just go to sleep and just stay there for the whole thing and wake up and then go back to sleep when we get home and sleep all night. Apparently it's not what they do. All right, sorry Annick, I missed the second half of that. So I'm not sure how well this links, but what I'm been asked to talk about is the challenge of writing a judgment as an academic. So as part of this project, I'm writing rewriting the judgment in Halligan and the Medical Council, which is a judgment about women's access to abortion. And we were asked as part of this project, or the task facing us in this project was to put ourselves in the shoes of the judge and to produce authentic judgments, so judgments that could really have been written at the time of the original decision based on the existing law and the existing social knowledge and the arguments put to the court in the actual case. And except that most of the contributors, apart from the one retired judge, are academics, not judges, so we haven't written judgments before. This is a very new exercise. We're used to writing about judgments, but we're not actually used to writing them ourselves. In the English collection, Hunter, McGlynn and Rackley reflect on the challenges of writing a judgment as an academic, and what I'm going to do today is just to mention a few of those challenges and to give some examples from some of the cases from this project. One of the challenges is choosing the right audience. So academics, they do write for a range of audiences. Some of us write blog posts, we prepare teaching materials, we might write policy documents or submissions, but by and large our academic work is actually directed at an expert audience who has a good knowledge of the legal parameters, even the field of law that we're writing about. We don't generally write for the public at large in terms of our journal articles. Judges, on the other hand, have to write for a whole lot of different sorts of people at the same time. They write for the parties to the case, the people who are bringing their dispute to court and their lawyers, and particularly for the losing party who needs to understand why it is that they didn't win the case. They also write for the potential appeal court in case the judgment is appealed higher. They write for future decision-making courts who may take this precedent into account in a future case. They write for courts in other jurisdictions who are interested in the jurisprudence of New Zealand, and for lawyers in general, and for legal scholars who might want to analyse the decision to better understand the law, and also for the media. So the audience includes people who are both intimately connected with the case, who have a real stake in the decision personally, but also quite a range of people who are interested in the development of the law more generally. It also includes experts, such as the lawyers in future courts, and lay people, such as the media and usually the parties to the case. So the challenge in writing a judgment then is to deal with the complex areas of law and write it in such a way that doesn't downplay those, that engages with them on the intellectual level that they need to be engaged with, but it is also accessible to lay readers, so that people reading the decision can understand it. To provide an example, one of the cases being rewritten is a case called Bruce and Edwards. It's a Court of Appeal decision from 2003. And in Bruce and Edwards, it was about the change in status of a piece of Māori freehold land to general land. And this enabled that piece of land, which had previously been protected in favour of certain beneficiaries, to be sold off to outside the Māori community to a particular Pākehā family. The legal issues, and it would lose the protection of Te Tura Whenua Māori Act 1993, which was the key problem. The legal issues in this case were really, really complicated, and the facts were really, really complicated. It deals with a very long and complicated piece of legislation, and also deals with issues of the law of equity. And so the challenge for the judgment writer was really to be able to write a judgment which would be accessible to the layperson, to Bruce and to Edwards, but also to the readers of our Feminist Judgements collection, whilst still addressing the legal issues to do with the legislation and the equitable doctrines, and to do justice to those legal issues. So second challenge of writing a judgment as an academic would be having to stick to the legal framework. So as academics, we actually have quite a lot of scope. We have room for creativity in finding new solutions to problems and proposing ways the law could be developed in theory. And as a feminist legal academic, I could therefore propose legal solutions which better serve women's interests. For instance, that might tackle direct or indirect discrimination, things like that. But judges need to work within the confines of the existing law. They're not speculating on some other sort of legal arrangement which they would prefer to deal with. They have to adjudicate the disputes based on the law as it exists at the time. And sometimes the law doesn't wouldn't necessarily enable them to reach the decision they might like to reach on a principle. If you put the law aside and just think about what result they want to meet, sometimes you just can't do that because the legal framework doesn't allow it. So this was quite a constraint, I think, on some of us as legal academics, because we're used to being able to take it where we want to. And as an example of this case would be Seals and Attorney General. That's the 2015 High Court case, which many of you may have heard about in the media. It was about euthanasia, so a woman who was dying from a terminal brain tumour, and she sought reassurance from the High Court that her general practitioner wouldn't be prosecuted if he were to provide her with the means of ending her own life, or indeed administer medication to her to end her life. Now, the High Court in the original case held that this was not possible, based on the current New Zealand law, and that the law reform in this area needed to come from Parliament, if at all. The feminist judge might want to reach a different decision on that point. They might want to place greater emphasis on bodily autonomy and allow the woman to determine when and how she ends her own life. However, this is actually pretty difficult to do when you look at the terms of the Crimes Act. The feminist judge might actually have no option, given the clear terms of the legislation, but to agree with the High Court that this is not permitted under New Zealand law as it stands, and to agree with the court that actually law reform does need to come from Parliament. They need to instead find a different way, a different avenue to express feminism within the judgment. For instance, they might tell the story in such a way as to portray the female applicant in a way that provides dignity to her life and to her story and to her anguish about the way her life is going to end. So that's the second thing. We're stuck with the law. The third one is challenges of the adversarial process, and it's a similar sort of point. As well as being bound by actually the legal framework, we're also bound by, and judges are bound by, the way that cases are presented to them, the way that cases are brought to the court to be decided. So when preparing an academic article that discusses a particular judgment, we have pretty much free range as academics over the subject matter. We write about the way in which we frame the discussion and the resources we draw upon in our analysis. But in an adversarial court system, such as the one we have in New Zealand, the parties to the dispute will frame the issues for the court to decide. They will bring the evidence to the court, and their lawyers will make submissions about how the law should be interpreted. And the judge needs to decide between these two sides to the argument which are presented to the court, based on the material that is presented to the court. Judges don't have free range to write whatever it is they want based on the subject matter of the dispute in the way that an academic might. So this is actually quite a constraint when you're used to having broader scope, but at the same time, I was thinking about this in the car on the way in, it's actually in a way, it's a blessing in disguise, because once you take away the unlimited scope and you provide a structure, it actually does focus your attention and in some ways it makes it easier. You don't have to solve all of the problems, you just have to solve the problem before the court. So this is a challenge, but it's also an enabler. In our project, we didn't have the opportunity to attend the court hearings as judges, so we weren't able to raise the points we would like to be raised to the parties and allow them to make submissions on those points and provide their perspectives on them. We were restrained by the terms on which the case was argued before the court in the original case. So let me provide one example of that, the case of Lanco and Rose. This is a Court of Appeal case from 1995 to do with relationship property upon breakup of a de facto relationship. The original judgment resolved it using the rules of constructive trusts. And the judgment writer, and this is one of the ones that was rewritten by a man, managed to identify several alternative approaches, legal approaches, which would resolve the case in a different way and reach actually a more favourable outcome for the wife, and it wasn't a wife, for the female partner. And as an academic, he could canvass all these options and discuss which would be the best option to come to resolve the dispute. However, it turned out that those alternative approaches weren't argued before the court, so that the parties hadn't had opportunities to make submissions about those alternative approaches. There wasn't material about them or precedents before them about them put to the court. And this meant that that particular judgment writer wasn't actually able to include that discussion in his judgment. He needed to stick to the material provided in the original decision. So the feminist judge was restrained from using these, I guess his creativity was restrained in this sort of way. He had to stick to the way the particular case was framed when it was actually heard by the court. Probably the most important difference between writing a judgment and writing an academic article is that you actually have to reach a decision. So as academics, we tend to be quite tentative. We don't have to be so bold in our assertions. We can sit on the fence a bit. We can sort of canvass options and suggest things and use tentative language. But as judges, and I guess there's a comfort in that, being able to sit on the fence. And there's a discomfort in having to actually reach a decision, which will have impact on people's lives if you were a real judge. And also have impact on the development of the common law in the future. So there's a real responsibility in that, which was brought home to me in this project. So the case I'm rewriting, Halligan and the Medical Council, it was about the duties of a doctor when a doctor who has a conscientious objection to abortion, when a woman who is seeking abortion approaches their doctor. What should the doctor do? And I had sympathies for both parties to the dispute, to the doctors who have the sincere belief that abortion is wrong, but also to the young women who are approaching that doctor seeking help. As a feminist judge, I had to decide between them. So one of them had to win, one of them had to lose. Whereas as an academic, I might have been able to come up with some kind of created third way which actually recognised the interests of both parties in a way that the way the legal dispute didn't allow me to do that. So there had to be a winner, there had to be a loser, and the parameter of the debate was set by the parties to the case. Overall, I'd say that it's much more confined than academic writing. The parameters within which we had to work were more confined. And I became very conscious of the potential effect of, if I were a real judge, the potential effect of this decision on people, which is, I guess, a real responsibility that we don't necessarily, or we probably should take as academics too, but it was more alive to me in trying to write a judgment. It also gave me a great source of respect sense of respect for the judges who do this on a daily basis, and the incredibly disciplined way they have to behave when reaching decisions. Thank you.
Thank you, Rhonda. And continuing really that theme, we have Natalie who's going to talk more about donning her judicial robes.
Thank you, Elisabeth. Yes, I feel as though I should be actually putting on some robes for my piece. I've been asked to talk about how I went about finding my own judicial voice, and I feel slightly self-conscious about that. I can see at least one judge in the audience. Here am I presuming to be a judge. But actually, what I would say, it was really fun to pretend to be a judge. I certainly enjoyed it. So I guess by way of introduction, as noted by others, we were trying to write plausible judgments that were possible within the constraints of the law at the time. And when I first got involved with the project, I picked up the Australian Feminist Judgements book. And I just selected at random one of the judgments, and I read it, and I got to the end of it, and I thought, oh, what was feminist about that? And what I liked about that was, that's the point of the project, actually, is that the judgments that we're writing shouldn't be sort of obviously radical or feminist, right? They should be judgments that could have been legitimately written, and that in itself is really the radical nature of the project. But what that meant for me, actually, because I think I'd probably got involved with the project thinking I'm going to be writing a radical, feminist judgment, was actually I needed to find a judicial voice that both did the job of writing the judgment while also sort of being consistent with the feminist nature of the enterprise. So that was quite a challenge right from the start, how to write a judgment that was going to be a feminist judgment, yet was also going to be consistent with the law at the time. So how did I go about finding my own judicial voice? Well, I'll explain a little bit about my case, the case that I worked on first. It was a David versus Goliath type of battle, although in this case it was Mrs. Joan Lawson versus the national government of the 1990s. The case was Lawson versus Housing New Zealand, which was a 1996 High Court case, and Mrs. Lawson was challenging the government's shift to market rent rates for state housing properties. She'd been living in a state house for nearly 50 years, the same state house in Onehunga in Auckland for 50 years, and the government was going to increase her rent by over 100%. She challenged that decision as a judicial review proceeding, which is challenging the process by which the decision was reached, and she lost in the original case. So I set out to rewrite that decision from a feminist perspective. Initially, I took a fairly organic approach to finding my judicial voice, and so what I mean by that is I really just sat down and set out to write my decision, framing it as the case had been originally framed. And I let my sort of feminist voice emerge. But reflecting on that, now that I've got a good solid draft, I can see that there are 5 factors which had some influence on my judicial voice. First of all, I started initially by trying to rewrite the original judgment, right? So I actually took the text of the original judgment and picked it up and went from the beginning. Which you can do, actually. You can't do that in an academic enterprise because that would be plagiarism, of course. But in rewriting a judgment, that's entirely legitimate. So that's how I began. But actually, as it went on, it's become more and more my own voice. There are certainly some paragraphs that are to be found in the original judgment, but the more I've worked on it, the more it's become my own style. And of course, I was wanting to insert a feminist perspective, so inevitably I was going to depart from the original text along the way. The second thing, I guess, that I tried to do in particular was to insert the voice of Mrs. Lawson. So something Annick mentioned at the beginning, sort of asking the woman questions. So my plaintiff was a woman. The move to market rentals for state houses had a bigger impact on women. And so what I wanted to do was put Mrs. Lawson's story into the judgment. And in the original judgment, Mrs. Lawson's story is there. I got all of the facts about Mrs. Lawson from the original judgment, but her story was buried in the middle, and I put it right up front at the beginning of my judgment, and I sort of expressed it in a stronger way, is probably how I would describe that. And so I see that what I was doing there is making the case about Mrs. Lawson, not about some sort of distant plaintiff. The plaintiff complained about the move to state housing, when it's actually Mrs. Lawson in her mid-70s who lived at 27 Oranga Ave for 50 years complained about. So I was trying to put more of her story into my judgment. The third thing which Rhonda's also mentioned was about the need to be disciplined and the need for restraint. So at the outset of the project, actually, we had a fabulous workshop with some real judges, and one of those was Justice Susan Glazebrook from the Supreme Court. And she gave us a great paper with some tips on judgment writing. So one of those was keep it snappy, she said. Unclutter the judgment, aim for quality, not quantity, avoid long quotations, and if it's not relevant, exclude it, even if it's interesting. I really enjoyed that. I really enjoyed that kind of editing out everything that was not relevant, taking out all of the clutter. The fourth thing also mentioned by Rhonda was the need to stick to the law, right? To write a judgment that was plausible in terms of the law at the time. And my case had 6 issues needing decision. And when I set out, I initially intended one of the issues was about whether or not the right to life, which we find in our Bill of Rights Act, whether or not the right to life in New Zealand includes the right to a certain quality of life. So in this case, the right to a certain quality of housing. That was the argument that was run. And when I set out, I thought, yes, I'm going to be arguing that our right to life includes the right to housing of a certain quality and affordability that's not too expensive. But as I got into it, I realised that simply just was not feasible on the state of our law as it was in 1996. And even today, that would be a stretch as a legal argument. And so even though I wanted to, and even though I believe, sort of from a sort of ethical point of view, I guess that would be the right conclusion to reach, I couldn't reach it. But what I did do, this is probably, I'm looking at Rachel here actually, probably departing a little bit from the judicial task, I did have a little bit of obiter in there to say, well, even though I can't reach this finding, the law might be developed in this way, or this is something Parliament could look at, possibly a little bit of clutter there to indicate my dissatisfaction. Then the final thing that I was able to do, not all judgment writers could do this, but because my original judgment was 20 years old, it was 1996 decision, I had the luxury of being able to do a little bit of crystal ball gazing. So I'm rewriting my judgment as if it was 1996, but I could look at future cases that had been decided in the interim and indicated the direction of the law. So I had the luxury of doing that, which was, of course, quite fun. But in the real world, of course, judges don't have the benefit, the ability to do that. I was left at the end with a real new respect for judging. The constraints of judgment writing are narrow, certainly, as Rhonda said, in comparison to what we usually do as academics. But I had this real appreciation for the way in which you can only reach a decision based on the facts and the evidence and the submissions that you've been received, and that's what you have to work with. And like judgments in the Australian project, I found judgment writing empowering and liberating. I really enjoyed it. It was fun. I liked those constraints, actually. I found having that framework helpful. And I also enjoyed that sense of writing about a real decision for real parties that mattered, even though I am 20 years after the event in my case. I've tried to track down, actually, Mrs. Lawson, but I haven't had any success. She was in her mid-70s back in 1996, so she'd be in her mid-90s by now. Yeah, thank you.
Thank you very much, Natalie. And the last sort of piece of the puzzle really is not just thinking about feminism in action by rewriting judgments, but also feminism in action by the process of the project itself, which is one that very much emerged collaboratively and will do as we complete the project over the course of next year. So to reflect a bit on that, both the pros and the cons, Ursula, Chair, welcome.
Kia ora koutou, everybody, and Thank you very much, Elisabeth, for that introduction. I'm sorry, Rhonda, I almost heard nothing of what you said, as you could see why, and this is why women are distracted by looking after children. It's not because we go mad or lose our brains or anything like that. So it's a great pleasure to be part of this project, and I've been asked to comment on the aspects of it in relation to the collaborative side of it. And this caused me to actually reflect on my own career, and I thought, oh gosh, I haven't collaborated very much. This is one of the real collaborations I've ever done, but I've been an academic for over 20 years, and I actually looked back and realised I had collaborated quite a lot, and they're all quite different projects. So I thought I'd just give you some examples which will give you an idea of, more of an idea of what academics do actually. We don't just sit around gazing into the middle distance and coming up with highfalutin, dry, dusty ideas and then put them down on paper. And then I'll talk about the challenges and the benefits generally of collaborative work, and focus particularly on this project. So I've actually worked on collaborative projects within my own law school. So we have a fluid research group in which members move in and out as they are able to, depending on their other work. And we're dealing with a longitudinal project that's looking at how law students experience their law degree. And as I said, that's longitudinal, so it's going on year after year after year. So that's a very interesting fluid sort of collaboration which seems to be working quite well as it goes on. I've worked with my colleagues also on a big project that we did after the earthquakes, which is still ongoing actually, in which we all contributed to the research generally by doing our own work or working with research assistants on law and how it relates to natural disasters. So I wrote my own paper for that with the help of an RA, but then the leader of that research project, Professor Jeremy Finn, turned a version of that paper into a chapter in a book. So there were many things that were done with that research as we went along. I've worked within the university on for example, a paper for a government commission. So I worked with two other academic colleagues in the university, and we all did our own piece of this paper, and then I knitted it together. Now that was the first collaborative project I was involved in, and it was probably the worst when you think about it. One of the papers that were due by a certain date just didn't arrive, and when it finally did arrive, it didn't look anything as we'd expected. So we just hadn't really collaborated. We'd all decided what we were going to do, and then off we went and did it in isolation, and then it fell to me to knit that one together, and it took a bit more work to do that. I've also worked, chaired a review panel in the university in which I worked with 5 others who we were reviewing the postgraduate academic offerings in the College of Arts, and that was an interesting project in the sense that again I had a team around me. We worked together for 2 or 3 days listening to evidence about what was going on in the College of Arts. Then we discussed what approach we would take to our report, and then everybody went away and worked on part of that, and again I knitted that together, and that did seem to work very well. Within New Zealand, I've also part of a national project now, which of course this is a national project as well, and I'm in the early stages of a proposal that's going to go to the Law Foundation, the same body that is supporting this project, looking at the effect of the development of IT and how technological developments are affecting the law and impacting on the law. And that team's going to be very interesting because it's going to be across all law schools, and it's also going to be interdisciplinary. So it's not only going to be legal academics working on that, and it may not even be academics. We may go out into industry, and so that will be quite a big project to coordinate, but very interesting in the sense of the challenges and benefits of collaboration. And then internationally, I have actually prepared a chapter for a book about privacy and defamation, my area of speciality, and we did do that work by preparing drafts and then presenting them at a workshop, which is what we've done as part of this project as well, and I've found in a collaborative sense that works very well, and I've very much enjoyed that process. So just talking about, first of all, the challenges of collaboration. I've just got a list really of some here. First of all, finding where you fit in the project and what you can contribute to it. And in this case, it was very collaborative from the start in the sense that we were invited to offer cases we thought we could write about. But the other part of the project, of course, is that in the book that's going to be published, the cases don't come first. A commentary on the case comes first. That's right, isn't it, Elisabeth? So the commentary, and I'm writing a commentary on one of the judgments, is obviously shorter than the judgment, but it discusses what the case is about in a fairly straightforward way, and then it comments on what the feminist judge has done to that judgment, and then the full judgment follows. So working out who would collaborate and what we would who would commentate, what we would commentate on, who would write the cases. That was an interesting process, and we received guidance actually, and in the end, for someone like me, who in my area of media law, which is my area of speciality, I had a bit of trouble finding a case, so I ended up doing a commentary, and I was very happy about that. It was no problem for me at all. Okay, so other things that are challenges as regards collaboration, you may need to travel. So there's been a workshop in Wellington, there's been a workshop here, and Elisabeth has travelled now for this presentation, and if there are other presentations and so on, there will be this travelling element. So funding will be an element of that, paying for who's going to go where and how you're going to get there and how you run the workshops and those sorts of things. Obviously getting funding from the Law Foundation and so on is very important to this sort of collaborative work. But I would say that I think for women, travelling is often difficult to arrange. And, you know, your timetables, if you have young children in particular, it's hard to leave your family for a while and work out when you'll be able to do that, apart from finding the funding and so on. Allocating the work in the best way. I've actually talked about that when talking about how we worked out what we were going to do. Meeting deadlines, obviously. You're in a group and there's quite a commitment to your goal, so it's very, very focused, and meeting deadlines is a very important part of that. And then the organisation around that and letting us know what's expected of us and telling us the dates and what's happening next and so on. And I must say Rhonda has been highly efficient in that regard and very, very helpful, I have to say. But looking at in terms of workshops and that sort of thing, being unafraid to share your work is quite a big ask. With academics, it's quite nice to be isolated and work alone in your office, and as the others have described, it's just write on what you want to write on, and you might talk to other academics in your department or perhaps others that you're close to in your work. But having to share that openly in a workshop situation is quite a challenging thing, and there has to be trust there around how others are going to give you feedback, and well, you've got to front up to being able to deal with that and appreciate it and take what take from it in a useful way. And indeed, as the reciprocal part of that is learning to give constructive feedback, learning to be candid but professional, so being direct, and everyone has different ways of sharing feedback and direct and indirect approaches to doing that. There's one I've called getting the vibe of what you're doing. So getting the feeling for the project and starting to live it in a way that feeds into your work and feeds into what you're doing for the others in the group as well. Your responsibilities to the group generally, I've talked about deadlines, but there's more than that. You know, getting to the workshops on time, taking an equal part, contributing, all of those things have to come together. And overall, finding the time to do everything well. We are academics now more and more facing more and more pressure and having to do more in less and less time, unfortunately. So trying to find the time to actually give back to the project in a way that means you feel you're doing it justice and you're doing the best you can. Okay, in terms of benefits, having talked about the challenges, experiencing new ways of researching, so you're seeing others researching in certain ways. This is a completely new project for me to experience, and seeing what others have done and being able to do something new myself has been wonderfully rewarding. meeting new people, it's pretty basic, but also putting faces and names to people that you know of in other law schools, for example. My feminist judge is Janet McLean from Auckland, and I've known about her for years, but I've never actually met her. So it was wonderful to meet her at the workshop when she shared her judgment and I shared my commentary on her judgment. And this helps reinvigorate your approach generally. It gives you new thoughts about your research and what you're doing and what you can do to do it better. You have a supportive environment within collaborative work. You're just not on your own. You are not isolated and wondering if what you're doing is okay and so on. Sharing different perspectives, sharing your work and enjoying the work of others. Trying new things, being pointed in new directions. Obviously, when there's positive or useful feedback given to you, there are things you don't have to take them all. They're there for you to use as guidance about what your next step might be. New skills, obviously getting new skills if you're doing things you haven't done before, new sorts of research and so on. But overall, I think being part of a team with a shared goal, and I've called that riding the wave. There's kind of this wave thing that happens, that it's the wave and the vibe, and you're on the top of it, and we're kind of building up steam and moving towards that shared goal at the end of it, which is very exciting and very inspiring. Just to finish up by talking about a few things relating to the case I had to do a commentary on. This was a case called Brucker, which involved a question of whether a man who had protested outside the house of a female a policewoman on the West Coast, and he was protesting because he believed that she had been effectively following him around and making life difficult for him and sort of harassing him. So this man, who came from a family that understood the tradition of protest, he set up a protest outside her house and started playing a guitar on the grass verge outside her house from 9 o'clock in the morning, when he knew she had come home from work from being on night shift. So it was a very focused sort of protest and very different to the other sort of protest he carried out, which was outside the police station in downtown Greymouth, I think. So I had already written various comments on this case when it came out, and the court had to decide whether this man had committed a summary offence and what part his right to protest would play in the determination of whether that criminal offence had been committed. And into the mix of that came the policewoman's right to privacy. Did she have a right to privacy that meant he had overstepped the mark and that the protest wasn't effectively a real protest and therefore he should be convicted of the offence? So I had written about it from the position of a privacy lawyer. And now, looking at the commentary and looking at the case again, I've kind of turned the case inside out almost in a way to see it from the policewoman's perspective, which has given me, as I say, a new way, new eyes to look at this case and see how our judges open out these judgments and look at them from a feminist perspective. And I've learned also that that doesn't mean it doesn't have to be a hugely new and original perspective. I think something a number of us didn't quite understand was that sometimes what was being done was what might be done in cases from a human rights perspective, and there was nothing wrong with saying that was the feminist perspective in the case. We didn't have to just see it as being something new and completely different that only feminist judges would do. So the others have discussed the perimeters of the case, the judges being confined to that, and using the law pretty much at the time that the judgment was made to make sure that the judgment reflects those constraints as well. And I think our feminist judges have done that amazingly well. So in terms of collaboration, I think I would say that this collaboration I'm involved in is probably the most close up and sort of warmly embracing collaboration that I've ever been involved in so far, and I'm really enjoying. We do, babies as well, babies on top of that. We get to, I'm finding those there are extra benefits in this particular collaboration. So I think at this time of my career, it's a really a good place to be in terms of being involved in a collaborative project. So thank you very much.